This video analyzes the landmark Supreme Court ruling in Sustainable Ōtākiri Inc. versus Whakatāne District Council from 2026, exploring the complex balance between environmental protection and legal costs. The case involved a battle over regional waters. On one side were the defenders, the community group Sustainable Ōtākiri Inc. and the local IWI authority, Te Runanga o Aotearoa. Opposing them were the developers, Ōtākiri Springs Limited and the Whakatāne District Council. The court set a unanimous precedent regarding Section 104(1)(a) of the Resource Management Act. It affirmed that downstream environmental impacts, including the disposal of plastic water bottles, are legally relevant when considering resource consents. The IWI authority, Trona, acted to protect the life force of the water, known as Te Mauri o Te Wai. This was recognized as a matter of national importance under Section 6(e) of the Resource Management Act. Despite winning the legal precedent on plastic waste, the appellants faced a Pyrrhic victory. Under the quotes follow the event rule, they were held liable for the legal bills of the commercial bottler and the council. The appellants were caught in a 4-year procedural trap. A critical failure at the Environment Court level, specifically not seeking leave to introduce evidence on plastic life cycles, prevented the Supreme Court from overturning the consent. To calculate the final cost, the base fee of $51,000 was halved due to a 50% public interest discount, resulting in a net liability of $25,500, split between the two defending groups. The court rejected joint and several liability, opting instead to apportion costs. This protected the two groups from cross-liability, allowing them to pursue separate legal paths based on their distinct focus areas. A minority dissent in the 3-2 split decision argued that costs should lie where they fall. The justices warned that punitive financial penalties create a chilling effect, discouraging citizens from raising vital environmental issues. This case highlights two competing views of environmental justice: a pragmatic focus on economic certainty and property rights versus a progressive view prioritizing access to justice and treaty obligations. Internationally, New Zealand occupies a compromised middle ground. While Europe utilizes the Aarhus Convention to minimize costs, and the US follows a pay-your-own-way model, New Zealand relies on ad hoc judicial discretion. The root cause of this long battle was a lack of front-end capability. Local council planners lacked the frameworks to assess plastic life cycle risks, pushing the burden of defining the law onto community volunteers. One proposed solution is the implementation of protective costs orders. These would allow groups to pass a merit test and set a financial cap on costs at the start, ensuring legal advocacy remains accessible. Alternatively, moving toward proactive compliance through mandatory training for councils could prevent the need for litigation entirely, shifting the focus from punitive measures to accurate assessment. Ultimately, true bicultural jurisprudence requires systemic reform. To protect Te Mauri o Te Wai, New Zealand needs proactive capability training and legislative cost protections to ensure the defense of our environment doesn't require financial martyrdom.